My name is Harold Malkin. I'm here together with my partners Mike Nesteroff and Neil Evans. Neil is in our Lane Powell's Portland office. Mike and I are in the Seattle office. And just wanted to give you a brief overview of what we intend to cover today. Both Neil and I were assistant U.S. attorneys. I was in Seattle for about 20 years. Neil was in Portland. So we're going to give you a little flavor from, or Neil is going to give you a little flavor to start off with respect to his law enforcement background, the kinds of issues that organizations, courts in particular, might find themselves running into enforcement actions in connection with when you are dependent for some of your funding on state and federal funding sources, and when you also have large construction projects and do other types of procurement work, some of the federal and state statutes that apply to that. Mike Nesteroff is in charge of our environmental practice at Lane Powell. Mike's going to talk about some of the clean water, clean air, and other related statutes that apply to ports, things you need to be mindful of. And then I'm going to conclude the presentation with a presentation that we have given to a number of different audiences, in-house counsel at some of our large corporate clients, organizations like this where there are lawyers who from time to time may find themselves confronted with the need to conduct an internal investigation, give you some best practices and so basically a roadmap to follow in deciding whether it's the kind of thing you can do in-house, you should employ outside counsel to think about for you and conduct the investigation, and just some best practices to follow. So with that, I will turn it over to Neil. We hope to have a few extra minutes at the end of the presentation for some questions. Our contact information is at the end of the slide deck, and we are starting about 8 minutes late, so if we run over 1 or 2 minutes, it's not our fault. Neil?
Thanks, Harold. So my name is Neil Evans. I spent 25 plus years as an assistant U.S. attorney in AUSA doing civil, criminal, fraud work, and some environmental work. And so what it very briefly, just in 2 slides, cover some basics, and then I'm going to put my AUSA criminal or civil prosecutor hat back on and talk to you about what a prosecutor would be looking for and what they're interested in, and a little bit later, after Mike's spoken, some of the mechanisms that prosecutors use to conduct their investigation. So as I'm sure all of you know, there's federal and state funding sources for the ports. You go to I went to the EPA website, and there's a laundry list of grants and sources of funding for you. Department of Commerce has money. Army Corps of Engineers, who I've worked with before when I was with the government on environmental and port issues, EPA, FAA, U.S. Department of Transportation. I'm sure whether you're staff or a lawyer, you are fully aware of the currently, I think under what's called the Port Infrastructure Development Program, there's $292 million available, and $92 million of that has been set aside for the top 15 ports in the United States. Seattle and Tacoma are in the top 15 ports. So there is a lot of money out there to go get and apply for and to work on certain projects. I have not looked at the actual applications, but we'll talk a little bit about what a prosecutor would be interested in, what you and your staff put on that application. In Washington State, there's this diesel program liability. Again, there's state and federal sources of funding. What comes with that is there's the potential for state and federal investigations, inquiries about the statements made on your applications, the use of the funds once you get them. Washington State has a False Claims Act statute. Oregon has a False Claims Act statute. I'll talk a little bit about the levels of enforcement that you might see in your ports. So there's criminal and civil liability. There's also what I would just call kind of commercial contract liability, depending, that would normally be dealt with at the agency level. So whoever your staff person is that's administering that contract or grant with the government, they will have a counterpart in the government. And that counterpart may say, look, I'm seeing some problems, or there's some issues here. How are you complying with, whatever it is, maybe term 3 of the contract? And that will be dealt with on an administrative level. I think what we're talking about here more is that whatever problem there is gets elevated to a potential civil or criminal liability, right? And that liability attaches to false statements that may have been made in the application. You know, we need $1 million to fix X. Well, as it turns out, you know, you were using that $1 million, you always intended to use that $1 million for Y. So you don't use it for its intended purpose. So there's false statements on the applications. Typically with grants and funding, there's an annual, maybe a semi-annual reporting requirement. You have to submit something to whatever agency has provided you those funds. That can contain false statements. So if you're falsely reporting what you're spending the funds on, it's a two-year funding program. We've spent 50% of it. We've already spent $500,000, and we spent it the way it was intended to spend. And yet I don't know, maybe your CFO is driving around in a new Mercedes or something. You know, that was siphoned off, and you know it. And the person who signs the attestation on the reporting knows that some of the funding got siphoned off. So there's false statements about the actual funding. There's the false statements on the reporting. There's also material omissions. So if there's a question that asks you something specific about how it was spent, and you don't fully answer that question, and if you had fully answered that question, if you omitted some material information, material is generally defined as some information that would affect whether or not the government entity would pay you what you've applied for or what you've submitted, that's material. So again, if you are saying in your semi-annual report, we have spent this money on X, and really what you did was you spent it on X plus a little bit over on Y or a little bit somewhere else, you're omitting material information that would impact the decision of the government entity to make that payment. That could be part of the liability. There's also pretty obvious problem of kickbacks. Kickbacks, if you're providing those to, or if one of your contractors is providing them to a sub, or the contractor or the sub is perhaps providing it to the port entity, that is an issue. And here's really a laundry list of the more likely criminal and civil statutes that would be used by a U.S. Attorney's Office. So when a U.S. Attorney's Office is going to investigate expenditure of federal funds, state and local prosecutors, county prosecutors will maybe look at, and the state AG's office will look at the expenditure of state funds. As you can see here, starting at the top, just a plain old false statement. Conspiracy. Conspiracy is nothing more than an agreement. And so if somebody from the port has a conversation, sends an email, as an investigative agency, thank goodness for emails, we complete what people put in those. If somebody sends an email saying, hey, look, if you bump up your budget by $10,000, and we'll bump up our budget by $10,000, then we'll get an extra 20 and we can spend it on something other than X. And lo and behold, the application comes in at $20,000 more than what you really need. That arguably is a conspiracy. There's an agreement to make a false statement on an application which could get you in trouble. And we'll talk about whether or not $20,000 is going to result in a federal criminal charge under 371. But that's all a conspiracy is. It doesn't take much. Theft of public money is pretty clear. False statements is pretty clear. On most federal forms, there is a certification on the bottom. It says, I hereby certify that the above statements are true and correct. And if not, it's all in violation of 18 U.S.C. 1001. That's pretty clear. As a prosecutor, you love to see the signature just above the certification below that says, if you lie to me, it's a felony under false statement 18 U.S.C. 1001. There's a bribery statute, kickback statute. False Claims Act statute is a civil statute. That is what you will see most often when you hear about quite frankly, up here in Washington, the Boeings of the world, the big healthcare companies, getting hit on a civil settlement for making false statements to the government about, and it could be, in the False Claims Act world, it's often about providing services to the government. So is there government funding that's gone to somebody as a result of a false claim made to the government? The beauty as a prosecutor of the False Claims Act is it allows for up to 3 times the damages, treble damages, and a pretty significant penalty for each and every false statement. So in the healthcare world, you will see, what, Harold, 90%, 95% of those cases get resolved because it's settled, because the risk of going to trial and losing is so great when you have hundreds, if not thousands, of claims made on, for a particular medical procedure. So to put it in your terms of funding, getting a grant, and maybe you've got a monthly draw that you make on that grant. Maybe there's a false statement in the application, and to obtain that grant, you get it, and then every month you draw down. Arguably, every month that you certify that you're in compliance with the grant terms, or that you say, I'm spending this money on X, that's an additional false claim to the government under the civil statute, and those penalties can add up. So again, those are just examples of the criminal and civil statutes that are involved. So putting my prosecutor's hat back on, whether it's a civil case or a criminal case, or oftentimes an agent will come in, and each one of these agencies has an Office of Inspector General. If the fraud is large enough, or maybe it involves national security money, the FBI could get involved. EPA certainly has agents, criminal investigative agents. They will come into the U.S. Attorney's Office, and more often than not, the prosecutors want to know how much money's involved. How much money's involved overall, and how much money do you think was subject to fraud? In the environmental arena, it's, how many dead fish do you have? What's the environmental damage? What's the extent of this? And in part, on the criminal side, the extent of the damages drives a sentence. And I sort of hate to admit this as a prosecutor, but too often, Harold, I think you've probably seen this, the outcome, the potential sentencing outcome dictates how interested a prosecutor is in pursuing the case. The potential damage recovery under the False Claims Act, is this going to be $1 million we're going to recover, or is it just a $50,000 case, will dictate how interested a civil AUSA is in pursuing the case. That's not to say, because I think another factor is how egregious is this conduct. Has this port been under investigation before? Has this port been penalized by the locals or by the state agency before? Have they been instructed or provided some information about what they're doing is wrong, and they went ahead and did it anyway? How egregious is this conduct, and what's the appropriate response from a government enforcement agency? And finally, a prosecutor is going to want to look at, how am I going to prove intent? How am I going to prove that the port or a port person in position of authority knew that this was wrong? In the criminal arena, you often need to prove criminal intent, so knowledge of what you're doing is absolutely wrong. In the civil arena, under the False Claims Act, you just need to show that the false statement was in reckless disregard of the truth, which is a much lower burden. And of course, it's a civil case, so it's by a preponderance of the evidence, where in a criminal case, it's beyond a reasonable doubt. So all of those factors come into play on whether or not it's going to be a criminal or a civil case, or perhaps if it's not a lot of money, it's not egregious conduct, you can't really prove intent, a prosecutor may very well say, look, you have remedies under the contract. You have administrative remedies to pursue. This is talking to either the agent or the government agency. you have those remedies you can pursue for what you think is misspent money or perhaps even false statements on the application or the drawdown of funds. That was really all I needed to cover. Again, I would just to reiterate that last point, there's administrative remedies, there's civil remedies, and there are criminal remedies, and you hate to provide the lawyer-like answer or statement, but it really depends on the facts of the case as to what kind of enforcement response you're going to get. Mike?
So I'm kind of the thorn between two roses. The two, as a former assistant U.S. attorneys, I'm the only one that doesn't have a background in with the prosecutor side of things. But I'm going to talk for a few minutes here about the myriad ways that you can go afoul of the various criminal provisions in the environmental statutes specifically. And up here I've listed some, but not all, because this is a pretty long list and we could be here all afternoon. But these are some of the bases for criminal liability under the Clean Water Act. So you have things like discharges to the waters of the U.S., which I will note, what constitutes a waters of the U.S. these days is in flux and subject to a great deal of debate and controversy, but nevertheless, somebody decides that you've made a direct discharge to the waters of the U.S., you can face liability. And it's not just a knowing violation. This particular part of the statute also imposes liability for negligent violations. Negligent violations as a basis for criminal liability. That should scare people, which is what our intent is to do here. So the maximum penalty under that negligence provision is a year in prison and $2,500 to $25,000 per day fine. Similarly, oil or hazardous substance violation of the Clean Water Act has both a knowing and a negligent provision. Then there's the failure to report a discharge. There's endangerment, where you know that someone is going to be in imminent danger of death or serious bodily injury. There's a false statement under the Clean Water Act, as well as the general false statement provisions. The Rivers and Harbors Act is probably one that you've encountered many times, but that has provisions for misdemeanor violations if you do something without a permit, and that can be up to 1 year in prison and fines up to $100,000 for an individual and $200,000 for a corporation. If there's a deposit of refuse, waste material into the waters of the U.S., there's a mandatory minimum of 30 days jail and a $500 fine. If you do construction in the waters that are covered by the Rivers and Harbors Act, there's a $500 minimum fine. So I went to the EPA website just to find out what EPA has been doing in the last few months in terms of criminal enforcement. And just to give you an example, under the Clean Water Act, just in the last couple of months, the city of Oswego, New York wastewater treatment plant entered into a criminal settlement. The superintendent of that treatment plant, a guy named Gary Hallinan, was in charge of the plant's centrifuge, which was a component that removed some of the waste material from sewage. In December of 2014, that centrifuge stopped working, and for 5 months he failed to take any action to remove sewage from the wastewater or to even report that there was a broken centrifuge to the New York environmental regulators. That resulted in discharges in violation of the permit on 3 occasions in 2015, and at times the concentrations of solid matter were 60 times greater than what was allowed under the permit. So the superintendent pleaded guilty to 3 counts of negligence under the Clean Water Act, and he was sentenced this last month to 2 years probation, a $1,000 fine, and 200 hours of community service. Another Clean Water Act case that just settled recently was a pet food component manufacturer in Nebraska. They had a waste discharge permit from the state environmental regulators. They specialized in processing animal materials and byproducts for the pet food industry. They exceeded their wastewater discharge permit greater than 2 times the daily maximum. The company entered into a agreement for a misdemeanor violation of the Clean Water Act and a $100,000 fine. And then there's a sewage treatment plant that served a private development in West Virginia. The owner admitted that between 2014 and 2016, he failed to maintain the treatment plant. It resulted in untreated sewage being discharged into the Potomac River and falsely reported quarterly testing on wastewater. So he pleaded guilty to knowing violation of permit conditions and false statements in discharge monitoring reports. He was sentenced to 5 years probation and fined $24,000. So there's also the Clean Air Act, which has a number of provisions for penalties, criminal penalties. So you could knowingly build a new facility or modify it, and if it's emitting hazardous pollutants, or if you fail to comply with the design requirements and you violate the emission standard, you could be subject to up to a 5-year prison sentence plus fines. Asbestos is the one that should raise red flags anytime you're involved with that, because there are criminal penalties, and that's one area where EPA has been pretty aggressive all along in enforcing all of the asbestos rules, whether it's exposure, permitting, and disposal. Any one of those could create a problem for you. And again, there's false statements and knowing or negligent conduct. So a recent example where the Clean Air Act criminal penalties resulted was an oil processing plant in Billings, Montana, where they constructed part of the equipment, but they didn't have all of the ventilation equipment in, but they started up anyway. And the project manager was aware that there were ventilation and electrical problems, and was conveniently writing an email that he noted there were risks posed because of the design construction, and quote, "We run the risk of killing someone, not only our operators, but also customers." And then in November, 4 or 5 months later, he still noted that there were deficiencies in venting. So then on December 29th, 2012, they were accepting delivery of a highly volatile and flammable natural gas condensate. And as it was filling up the plant because of the bad ventilation, the fumes escaped out the open door, and the truck that was depositing the material there set it off from the ignition, and it injured 3 employees, and there was extensive damage to the plant. The former plant manager pleaded guilty to Clean Air Act negligent endangerment, and he was sentenced to 2 years probation and a $5,000 fine. His co-defendant, who was the president and director of the company, went to trial and was convicted on 3 counts of conspiracy, the general duty owed under the Clean Air Act, and a knowing endangerment. And his sentencing has not come up yet, but it should be probably sometime next year. He will not get the lenient 2 years probation, I'm sure. And then just briefly, there's some other statutes involving hazardous substances. RCRA, the Resource Conservation and Recovery Act, is the big one that has to do with waste disposal. You can run afoul of that any number of ways if you don't have a permit and you knowingly dispose or even store a hazardous material. That could subject you up to 5 years in prison and $50,000 a day. If you have a permit but you violate it knowingly, that also could be a problem. A false statement there's liability under RCRA, and record destruction also. So here's the one cautionary tale case from this year. Electroplating services in Madison Heights, Michigan, it's just outside of Detroit. They stored and disposed cyanide, chromium, nickel, chloride, and various acids and bases. They didn't send it off to a licensed hazardous waste facility. Instead, they put it in drums, and then they put the drums in a pit in the basement of their building. Now, what could go wrong? Nothing. I can't imagine. The owner happened to know that the storage was illegal because he had managed a prior facility for the same company that had been busted for illegal storage, And in 2005, he had pleaded guilty to illegally transporting hazardous waste. This was in state court, though. So he got numerous notices of violation and warnings from the Michigan Department of Environmental Quality. And then in 2016, the state regulator identified 5,000 containers of this material that should have been sent off-site. The EPA declared it a Superfund site and came in and spent $1.5 million cleaning it up. So, needless to say, things did not go well for him. In his sentencing just earlier this month, the company was given 5 years probation and $1.5 million in restitution to cover the EPA's cleanup costs. The individual got 1 year in prison, 3 years of supervised release. So again, these are things that you should be aware of and be cautious of. And one last thing, there are also civil penalties under the Clean Water Act, the Clean Air Act, under RCRA and the Superfund statute, CERCLA, and EPCRA, the Emergency Planning Community Right to Know Act, which means you have to be reporting any storage of hazardous materials and any releases of hazardous materials. Those civil penalties have all gone up into the $55,000 range. And EPA is pretty aggressive about enforcing things, particularly under EPCRA. That's the one that Bill Powell was the started that statute going years ago, and they're very aggressive about policing that, whether it's a port or a warehouse or a commercial business. And now I'll turn it over to Harold.
Thank you, Mike. The next slide, slides 8 and 9 in your slide deck, are just civil and criminal investigative tools that most prosecutors, whether they be state or federal, have at their disposal. There's nothing new here, grand jury subpoenas and search warrants on the criminal side, and as Neil mentioned before, most federal agencies have offices of Inspector General, which have subpoena power, not for testimony, but for documents. And there's also something called the civil investigative demand that the U.S. Attorney's Office use. They can compel testimony prior to filing a lawsuit. They can also seek documents and answers to written questions. Now, why should you care about those? Because those can be, if you look on page 10 of the presentation, those can be among the triggering events for internal investigations, and that's really the tail end of our presentation. What do you do if you find yourself either in trouble and under investigation for having potentially committed one of the offenses that Neil and or Mike has identified, or whether you suspected that may have happened? No one has come to you and accused you of that, no one's investigating you, but there's some indication internally that there may be a problem. What do you do? How do you handle the investigation? So the types of things that are typically triggers for internal investigations are internal audits and compliance findings, to the extent that your organizations may have people who audit compliance, internal auditors or people who are in charge of monitoring compliance. If they come across something that could be problematic, that could be a trigger for lawyers, whether they be in-house or outside counsel. We'll get to the difference and the benefits of one versus the other in a moment, but that can be a trigger for an internal investigation. Hotline calls. I don't know how many of your organizations have hotlines, but certainly many public companies do, private companies do. People who can, employees or others who can pick up the phone, make some sort of anonymous complaint, can trigger an internal investigation. Same with employee, vendor, third-party reports. For ports, I think of airports, for example, people who use the facility. They may not be vendors, they may not be tenants, but they could be people who are just, passing through. See something, go to someone in a position of authority or make a phone call when they get to their destination, saying, I saw something that I thought was unusual, maybe somebody dumping something on the side of an airport runway, whatever it is. But those two, employee, vendor, tenant, third-party reports and complaints, can also be a trigger for internal investigations, as can press reports. There are all sorts of stories written in the national press about issues that arise at ports and similar facilities around the country. That could be a trigger for someone here in Washington State thinking, I wonder if we have a similar issue, and turning your attention inward to see whether the same thing might be taking place at your facility. It's not always a violation of law that gives rise to the need for an internal investigation. can be a sensitive HR matter. It can also be, we've represented a public utility district in Washington State that had an employee who was killed in an industrial accident. And we were brought in because there were some concerns that management and labor had about how transparent the investigation was going to be. And they brought in our law firm to serve as outside counsel, conduct the investigation. So it can be any number of different things that might trigger the need for some type of internal investigation. And the last one, of course, is should you find a federal agent on your doorstep serving a search warrant or a grand jury subpoena or an OIG subpoena or a civil investigative demand, there's probably something worth looking into. If the feds are looking into it, you'll probably want to know what they're looking at. Next slide, please. So what do? What's the purpose of an internal investigation? First of all, you want to determine if the allegations or the reports, the hotline complaint, has any merit. Okay, that's obviously the first thing you want to do. Then you want to identify what facts exist in support of or contrary to the report and apply them to the governing legal, regulatory, and contractual authority. See whether whatever it is that happened is contrary to what is supposed to happen under governing law or regulations, and then evaluate the possible consequences and exposure to a violation. What if there was a violation? What is the worst case scenario? What are we concerned about? What is the potential enforcement action? Are there individuals? Is it the entity that has to be concerned? And depending on the answer to that question, you may need to appoint counsel for individuals. It may just be the entity that is the subject of the investigation. Then the person who's conducting the investigation also wants to assess and opine what might be an appropriate response to whatever the facts were and the potential violation. And then finally, the person who's conducting the investigation or the entity that is asking for an internal investigation presumably is going to be interested in recommendations for remedial and corrective action. So that's generally the purpose, the things that you're looking for to be done in an internal investigation. Now, what are the important considerations at the outset? The first and most important one is to scope the investigation. And what do I mean by scope? You want to define what the relevant time period is. Typically, if there is a problem, it hasn't been going on forever. Sometimes it may have been going on for a long time. Sometimes if it has been going on for a long time, it's gone on longer than the statute of limitations. So scope what the relevant time period is. Try and figure out what the relevant universe of folks who should be interviewed is. And also try and figure out what kind of documents you're going to need, whether you're going to have to put in place, as you typically will, some sort of litigation hold, and what that hold is going to cover. What types of documents, who the custodians are, and make sure you get the document hold out to the right people. I think the most important question in many respects is who's going to conduct the investigation. Is it going to be conducted in-house, or is it going to be conducted by outside counsel? And there are benefits and I think disadvantages to each. With respect to in-house counsel, you guys know your organizations, you know your people. You are there, you can hit the ground running, so you can typically get off to a start more quickly. More cost effective, yes, most likely than hiring outside counsel. You know the organization, as I said, and it can be less intimidating for employees of your organization to sit down and be interviewed by a familiar face. That sometimes can be a consideration. Conversely, what does outside counsel bring to the table? First and foremost, if you're dealing with federal regulators, oftentimes there's a sense that there's a perception of greater objectivity and independence if you're using an outside lawyer or an outside law firm to conduct the investigation. That firm or that lawyer at the firm may have some special expertise in the types of federal programs or grants, procurement fraud, things of that nature that's the subject matter of the investigation. And as is true of people like me and Neil, we are certainly not the only ones, but oftentimes if you hire somebody who's had a relationship with the federal regulators, there's often a sense of trust that develops, and there may be a pre-existing relationship between the outside counsel that you hire and the agency who's responsible for the funding that you received or whatever the problem may be. Preservation of privilege is critical. At least at the outset, you do not want to be in a position where you're waiving attorney-client privilege. So think about the steps you need to take to ensure that the investigation is being conducted in a privileged fashion. including the retention of experts or third parties who are going to advise you. Make sure, you can always waive privilege later, but once it's lost, it's lost. So make sure you take steps at the outset to ensure that the investigation is covered by privilege. One thing you want to be thinking about at the very beginning is whether or not at the end of the process you're going to have a written or an oral report. And we'll go through reasons why you might choose one or the other. And then finally, an important decision is, do you keep whatever the form of the final report, whether it be oral or written, do you keep it confidential or do you release it publicly? You would think that for public agencies, that's a no-brainer of a question, but we've seen instances where public entities, public courts, have decided to keep internal investigative reports privileged and confidential and not release them. So that's an important consideration. I'm not going to bore you with privilege. I assume most of you, if you're here for CLE credit, many of you are lawyers. You know what the attorney-client privilege covers and doesn't. Essentially, it's communications between lawyers and clients for the purpose of seeking or obtaining legal advice. The same is true, that last bullet having to do with in-house counsel. Certainly, communications between in-house counsel and employees or others within an organization can also be privileged. It's not just communications with outside counsel. And work product. In many respects, certain types of work product are entitled to very stringent protection, subject to a showing of substantial need by the party who may be seeking discovery of that work product. Fact work product is entitled to less protection than opinion work product. That is to say, an attorney's mental impressions, notes, thought processes are typically entitled to greater protection than the facts that are found as part of an internal investigation.
Hey Harold, to the
Yes.
extent that there are non-lawyers here.
Sure.
I want to just give a warning about waiving the attorney-client privilege by disclosing communications to third parties.
Yes, you know, it is, as I said, once you lose privilege, it's lost. So when you are communicating with your lawyer or your lawyer is communicating with you, there should be an expectation that the subject matter of whatever the investigation is intended to remain confidential. And you should not be disclosing it with third parties, whether it's the person you carpool to work with, whether it's a spouse. It doesn't matter who it is. If you disclose it to a third person outside the organization, the chances are very good the privilege can be lost. Now, as a practical matter, someone going to know that you discussed something with your carpool buddy who does not work for the same organization, isn't a lawyer, isn't involved in the investigation? Probably not, but is it worth the risk? Definitely. Next slide, best practices to maintain the privilege. What are some things you should do to try and ensure that privilege isn't lost? First, internal and external documentation of the investigation. That is to say, the engagement letter, emails within the organization should be very clear that the purpose of the investigation is to obtain or to provide legal advice. Okay? You are seeking legal advice or you are giving legal advice on the subject matter of the investigation. Make sure the subject of the investigation is carefully defined in your engagement letter. Scope of the investigation, as we talked about before, one of the first things you do should be thoughtfully and not too broadly defined. The more broadly that you frame what the subject matter of the investigation is, the more you risk that someone is going to claim that it's not in response to a discrete concern or issue, but it's more a business issue. It's more of business advice than it is legal advice directed at a particular concern or violation. So discreetly and carefully circumscribe what it is that is the subject matter of the investigation. That is more likely to result in discussions or communications on that subject remaining privileged. The investigation should be directed internally and externally by counsel. Experts should be retained by an attorney, and the engagement letter with the experts should state that it is that the retention and the engagement is for the purpose of providing assistance to and legal advice to the entity, and there's an expectation that all communications between the third-party expert, whether it's a physical engineer, whether it's an accident reconstruction person, but communications must be stated to remain confidential. And finally, communications regarding the investigation you should always on your emails have privileged and confidential. It is not the case that an email that does not say privileged and confidential isn't entitled to that treatment, but it shows a certain degree of sensitivity and care to identify your communications as being privileged and intended to be confidential, and it is easier to withhold them, put them on a privilege log, and have an assertion of privilege sustained if you make it very clear that that was your intention. In terms of interviews, the Upjohn case by the Supreme Court back in the 1970s, I think it was, extended the attorney-client privilege to communications not just at the control group level of a corporation, but throughout a corporation or entity, so that communications between lawyers and all employees of a corporation can be privileged if the purpose of the interview is to gather facts so that the organization can obtain legal advice. Corporations, entities function through individuals. So you need to be able to interview those individuals, elicit facts from them, apply those facts to the governing legal standards in order to know whether there has been a problem and what the nature and scope and extent of the problem is. So when you interview, again, in-house counsel or outside counsel, when you interview employees in furtherance of an internal investigation, you should give these 4 what are called Upjohn admonitions. We tend to write them out and give them to witnesses. We try and do it and explain to them why we're doing it in a conversational way, because the last thing you want to do is get someone spine up thinking that they're the subject of the investigation. What are these legal warnings? What is the significance of all of this? You want to try and explain it in very layperson's terms so they understand it's just a fact-gathering interview, but with these 4 important caveats. First of all, if you're counsel, in-house or outside counsel for the organization, you need to make sure that the employee understands that you represent the entity, you do not represent the individual, and you cannot give the individual legal advice. Second, the purpose of the interview is to gather facts as a basis for providing the entity with legal advice. Third, the substance of the interview is privileged and should remain confidential. Employees should not go home and talk to loved ones, children, best friends. It really is critical that they understand that the subject matter of the interview cannot be shared with third parties. And then fourthly, you need to let them know that the privilege belongs to and can only be waived by the entity or the organization. The individual is not at liberty to waive the privilege. And furthermore, that the entity reserves the right to share any of the facts that are disclosed during the interview to third parties or governmental agencies. Okay? While the individual needs to keep the substance and subject matter of the interview strictly confidential, the entity reserves the right to share that information with regulators, and that's important to impart. If you just go back for 1 second to the prior slide number, there it is. Very important, Washington State is somewhat unique in this regard, that interviews with former employees for purposes of an internal investigation are not covered by the attorney-client privilege. Investigative interviews of former employees not covered by the attorney-client privilege in Washington State. No attorney-client privilege, even if interview relates to the scope of the former employee's employment, or if the former employee previously served in management. Once the employment relationship ends, so too the privilege. Important to remember. Yes?
A couple of questions about admonition number 4.
Yeah.
The first question is, let me ask both and you can address them as you wish. What remedies are there for the employer if the employee feels that they do wish to speak about what happens in the interview or about the issue that's the reason for the interview? And secondly, what if the employee wants to hold the privilege in the sense that they don't want their name disclosed as somebody who's provided particular information for various personal reasons that they may have?
Sure. So with respect to the first one, they need, first of all, you should assure, and I'm sure most of your, if not all of your organizations, something that you would tell employees is that you have a non-retaliation policy. They have to understand that they can speak freely to you and you're only going to get accurate information if they're not concerned about retribution and things of that nature. But with respect to what happens if they talk about the facts of the matter, as it were, outside the confines of the interview, that per se is not the problem. The problem is the subject matter and the substance of the investigation and the interview. My lawyer asked me this. My lawyer asked me that. I answered in response to this question this way. That kind of discussion is what they are not permitted to disclose, because then you lose the privilege over the communication between the employee and the lawyer.
But your first admonition says you're not their lawyer, so how do you square that?
Well, you can tell them, I mean, I don't necessarily see a conflict between advising them from your perspective that because the company is the one that holds the privilege, that they are not at liberty to disclose the substance of the communications between themselves and counsel. If they observe something, right, if they observe the accident, the incident, the spill, they're not muzzled from discussing what they saw with anybody, just like if an investigator came to their house the next day and said, I'd like to know what you saw, they're permitted to answer questions about what they observed. What they're not supposed to be talking about is what they discuss with counsel. I don't know if that answers your question, but that's the concern about waiver of the privilege, because the privilege only covers communications with counsel, not the facts themselves. That may be splitting hairs, but that's typically what you as a lawyer don't want to create a roadmap for investigators and having employees say, these are the 10 questions I was asked by in-house counsel.
Right, you've got a sharp knife there, so I'll leave that part of it. But what if the employee says, I don't want you to disclose what I've said to the public, to an adjudicator, or to somebody who may be the subject of an investigation?
Sure. Well, I think that if I'm the one who's conducting the investigation, I would probably say, if that's your position, then we are not going to proceed. Now, it may be that you need to work out some sort of compromise because the person is critical to the investigation. But you as in-house counsel, you as outside counsel, need to preserve for the entity the ability to disclose to regulators some of these facts. So you can always table the interview, you can start it up another time, and it may interrupt the sequence of the interview, but I think in the short term, in the moment, that's what you need to do.
Thanks.
Was there another question? Yes.
So granted, it's not attorney-client privilege, but it would that, under that Newman case, would that be that would be work product, wouldn't it?
The substance of the communication would not be covered by, so the former employee would not be bound to keep the colloquy between him or herself and the lawyer privileged. The notes, and we're going to get to that in a second, so good question, the notes would be covered by work product. Okay? So recognizing we're going a little bit over, I'll speed through the last two slides. Internal investigation best practices continued. Clearly mark interview memos as attorney work product, to your point, and include language that the witness was given the Upjohn admonition, and that the content of the memo is not a verbatim recitation. A statement that is signed by a witness is that witness's statement. It is not the notes and the mental impressions of the lawyer. So a verbatim statement is discoverable in most instances, whereas an attorney's notes typically will not be, because they contain mental impressions of counsel. Include observations about the witness's demeanor and credibility and some analysis of what the witness has told you. That will further help to underscore that your memo, that your report contains opinion, attorney opinion, work product, and isn't just factual work product. It'll help to maintain the privilege. And then you should just know that sharing work product with a non-adversary under a common interest framework will typically not waive the privilege. The work product privilege is typically lost only if you disclose the work product to an adversary. And that's distinct from the attorney-client privilege, where if you share it with someone who is not the client, you can and likely will waive the privilege. And then finally, should it be a written, should it be an oral report? What are some of the considerations? A written report suggests a certain seriousness of purpose. Your audience, the government regulator, may expect there to be some sort of tangible deliverable at the end of the investigation that's shared with them in whole or in part. The findings are memorialized in a written report and are less likely to be misconstrued or misinterpreted. And also transparency. If there is something at the end of the process, a 3, 5, 10, 15-page report that is provided to the public or provided to the board of directors, there's transparency about what was done, what the findings were. Why would you go with an oral report? Because there's nothing to disclose or produce. In litigation, subsequently, if somebody asks for the report, there isn't anything to fight about. There isn't anything to disclose. There isn't anything to produce as part of discovery. You can avoid admissions, some of which could be contained in a written report. It's obviously easier to control dissemination of something that isn't written, that was an oral report that was given to the board. And finally, as I mentioned before, you're not providing investigators with an investigative roadmap where they can go back and replicate the steps that you took to conduct the investigation. Who the witnesses were you talked to, what your thought process was. If it's an oral report, you can satisfy your obligation to your board, to your client, but not at the same time have something that in the hands of the government or a regulator is going to be useful for them to conduct their own internal investigation. They may be more likely to accept the results of yours. So I apologize for going a couple minutes over. The concerns about whether you keep a report confidential or you release it publicly, I'm sure is something that will be debated within your organization, and there are good reasons on both sides to do one or the other, but typically if you're a public entity, there may be an expectation that any sort of report or findings are going to be summarized and released. But with that, if you have any questions, especially because we kept you a little longer, you can reach one of us outside. Our contact information is at the end of the slides, and we appreciate your time. Thank you.